Thank you for joining us today for our first social justice conversation. It is now my great pleasure to introduce Jean Kelleher, Director of the Office of Human Rights for the City of Alexandria, Virginia. Jean will introduce our special guest, and now with great pleasure, Jean Kelleher. Jean?
Thank you so much, Audrey. It's my distinct honor and pleasure to be here today, and I want to thank Phil Hirschkop for joining us. Philip J. Hirschkop is an accomplished attorney whom I greatly admire. He was born in Brooklyn, New York, served in the Army as a Green Beret, was educated at Columbia, receiving his degrees in liberal arts and mechanical engineering, and he received his law degree from the Georgetown University Law Center. To provide some context today, I wanted to just give a brief overview on the Loving versus Virginia case. Loving versus Virginia is a landmark Supreme Court case that struck down laws banning interracial marriage in the United States in 1967. The court ruled that such laws violate the equal protection and due process clauses of the 14th Amendment to the US Constitution. The plaintiffs were Richard and Mildred Loving, a white man and Black woman whose marriage was deemed illegal according to the law in Virginia. Inspired by the civil rights movement, Mildred Loving wrote to Attorney General Robert F. Kennedy for help. The couple was referred to the American Civil Liberties Union, and that's where we pick up on our conversation. Phil, thank you so much for joining us today. And I would like to start with asking you how you came to represent the Lovings.
Well, it's all quite accidental, serendipitous. I graduated law school in 1964. The year before, I'd become extremely active in civil rights. I helped found the Law Student Civil Rights Research Council. And in the summer of 64, a month or two after I graduated law school, I was extensively involved in civil rights litigation in North Carolina and Mississippi. I supervising 200 law students, so I was traveling a lot in the Mississippi and Alabama area where we had law students working. I was visiting with my con law professor in Georgetown about some of this litigation, and a note was brought in. A young man was there who'd been a student of his, Bernie Cohen, who had the Loving matter and didn't know what to do with it. And so he came and he told my con law professor, who introduced us and recommended we should get together. I walked across the street with Mr. Cohen. He had the case in juvenile court in District of Columbia. And he told me of the case. The next night on a plane to Mississippi, I drafted up a federal lawsuit to be filed in the Loving case. It was only pending in state court at that time and sort of delayed there. I sent that to Cohen, and that led to him offering me a job in his firm and my becoming deeply involved in the case.
Loving versus Virginia was actually one of your first cases, and at least in the public mind, it was your biggest. Do you feel that it overshadows other parts of your career?
No. Loving was a rather simple case in many ways. We had no trials. We only appeared in court 3 times, once in federal court in a motion to dismiss our federal lawsuit, once a 20-minute short argument in the Supreme Court of Virginia, and then the argument in the United States Supreme Court. There were no depositions, and there were interrogatories. We only met once extensively with the Lovings. I actually only met them 4 or 5 times all told. So it didn't have all that interplay you have in other lawsuits and commitments you have to make. It was a significant case, not when it started out. It started out as a criminal case, just based on their sentencing. They had been forced to leave Virginia and told they couldn't return together, and that type of sentence is recognized as being illegal. So we always felt confident we'd prevail on that, but that was a real trap for us. If we did prevail, it could be much worse for them than if we didn't prevail on the issue of just the sentence. And then after the case was decided, we tried avoiding publicity for the safety of the Lovings. So for 25 years after the case was decided, I virtually heard nothing of the case and moved on to other things. There were many cases I spent more time on. They were more difficult, in many ways more enjoyable, in many ways more rewarding, but Loving played very little role in my career.
Very interesting. So can you tell us really, in general terms, which ones of your other cases that you found rewarding, that you consider more important perhaps, which ones they might be and why they were more important now retrospectively?
Well, the legal efforts I'm most proud of is I was sort of lead counsel for the groups opposing the war in Vietnam. I would deal extensively with John Dean and the people in the Justice Department and the Chief of Police in negotiating most of the major permits for practically all the major demonstrations held in Washington in the late 60s and early 70s against the war in Vietnam. I had my own police cruiser and passes to the Mayor Command Center. And there were a number of cases came out of that, mostly brought by the ACLU. I represented the Veterans Against the War, Jean Kelleher and his group, and when they were arrested at the Supreme Court, and a number of others, too many groups to list here. Tens of thousands of people who were let loose. Some were arrested, 1,000 or 2 at the time we saw in the May Day demonstrations. But we stopped the war. And I think that was the most significant thing I've ever been able to contribute to accomplishing. It was the democratic process at its best, which is very poignant in what's happening in our society right now. Soon after the Loving case, I brought Case Get Women into the University of Virginia with co-counsel John Lowe. And that was the first case for women in higher education. And soon after that, they adopted that as applying across the board. And once the 3-judge court in Richmond gave us relief there. Soon after that, I took a case to the U.S. Supreme Court that knocked out all the teacher pregnancy policies across the country and deeply affected teaching. And there were a series of cases like that. I brought the first statewide case on prison reform, and that led to a big movement in prisoner rights and the founding of the National Prison Project of the ACLU, which I chaired for about 20 years. And other cases, mostly I think after that was, I did a lot of animal rights work. I taught animal rights law for a while at George Washington Law School. And I was chief counsel of PETA, outside counsel, from its founding till a couple of years ago, almost 40 years. And did a lot of animal rights work and watched as that progressed enormously. So there are other cases that just I felt had more immediate effect from my efforts than the Loving case itself.
Yes, and certainly lasting effects, and we're all benefiting from those. Can you tell us a little bit more about your work with prison reform and how that came about? Was that through the ACLU as well?
No, at the time, there was no ACLU in Virginia. It's actually the prison reform cases with combination of the Loving opinion that led us to starting an affiliate in Virginia. Myself and 3 others helped found that affiliate. When Loving was first brought, they had to appeal to the national ACLU, and that assigned it to the National Capital Area Civil Liberties Union. That was the chapter or the affiliate in Washington, D.C., but it also included the very wealthy large suburbs in Northern Virginia and in Southern Maryland, Montgomery County and Fairfax County, principally in Alexandria. And from there, we needed an ACLU affiliate in Virginia. We got a letter from some prisoners. There was a little bit of publicity after Loving was decided. There's a statewide prison strike at the same time Loving was decided, maybe a month later, based by the Black prisoners in the state penitentiary. At that time, there were some notorious penitentiaries in the country, and Virginia was one, Rayford Prison in Florida, and Parchment Prison, and prison in Louisiana, and Arkansas and Mississippi were the most notorious. Some had a crank telephone they hooked up to a man's testicles if he didn't like what he was saying. Some hung him from the Virginia penitentiary. They hung prisoners from the bars and kept them 3 days, just their toes on the floors, if they wrote to the ACLU or wrote to counsel. And that led to my filing the first statewide suit again for prison reform, Landman v. Royster, and it brought massive change to the Virginia prison. We actually held many of the major substantive hearings before Judge Merridge, Robert Merridge, the federal district judge in Richmond, at the penitentiary in the evening. There were so many murders and rapists, they couldn't bring them all to court. So the prison project then took off and spread, and it brought enormous change in prisons across the United States. I'm very proud of that.
Mm-hmm. That's incredible work. And as you know, now there are civil and human rights programs nationwide that are working on advocacy to eliminate private prisons. Do you have, an opinion on public versus private prisons, and whether that's something that agencies should be spending their time and their focus on?
I'm totally opposed to the whole concept of private prisons. It's unworkable. And I know we're going to discuss later a little about the Black Lives Matter movement, but it's akin to part of the problems there. The prisons that we saw, especially these southern prisons, were run by all white guards, many from very rural areas where there was a great deal of systemic prejudice. So it was horrendous for African-American prisoners. In Virginia, we know that we had the horrible history of the Martinsville Seven young men, the same year the Lovings was sentenced, 1959. It was sort of a mass execution over 2 or 3 days. And Virginia had a history of not executing white men for rape, but only executing black men for rape. And the great civil rights lawyer, Sam Tucker, a lot of people don't know Sam's name, Oliver Hill, his partner. Sam's probably the greatest civil rights lawyer I ever met. He handled the appeal for the Chicago Seven. He raised that issue. It was one of the first times it was raised in courts about this massive exclusion of blacks, not only from juries, but how they were put into the worst possible sentencing procedures. It just was a time when it reached this time, that litigation.
Mm-hmm. And do you think it's possible via litigation to address, even now, prison reform, or is it best done legislatively or through public policy?
Well, the Scalia court decimated the ability to litigate prisoner cases in federal court. State court was a joke because state courts are so aligned with the power structures that if you get a good judge, you're fine, but very often you might get a judge who's too politically connected. You and I are both in Alexandria, basically, with our practices over the years, and we're lucky. We've had a history of really good judges there, but it's kind of a different city state from the rest of Virginia in many ways, Alexandria. But you went into the rural and the southwest counties, and the judge and the Commonwealth attorney were cousins, and they were all related to some guy who was running the local work camp, and we had road camps in those days. It's just horrendous private prisons. There's no way you can look over their shoulder. It's the main flaw, I believe, in the way police authorities treat minority people in this country is the blue line. And that was true of penitentiaries. They answer to nobody. Mm-hmm. They with the stroke of a pen, a prison superintendent could double a man's sentence. I say men, not women, because women were not remotely treated the same way at that time in prison. But they took away his good time, they took away his parole, and this was just a stroke of pen. And they had to answer to somebody. And we had a unique experience in that really changed my views on Black Lives Matter impact. The guards in the prison system of Virginia, as I indicated before, were basically from very rural areas. A lot of them from West Virginia, a lot of them from Southwest Virginia. They treated Black people horribly, and other minorities, but Black people were the main minority. Back then when I was doing litigation, it was not a very large Hispanic population as it's much larger now, and particularly when you get in some of the Western and Southwestern states. Once Bob Marriage, once the federal judge took control of that prison and said, you will do this and you will do that, these very same racist guards were able to do their job fine. They had adequate supervision and they had told where the lines are that they couldn't cross. It would be preferable to have someone more reasonable thinking, but it changed dramatically.
Well, Samuel Tucker is admired in Alexandria. And in fact, one of the newest elementary schools on the West End, as you know, is named for Samuel Tucker. But it's fascinating for me to hear you call him Sam because you knew him so well. And it's wonderful for his legacy to know that he is thought to be the finest civil rights lawyer in your mind. I think that's great.
Well, I'll give you an interesting tidbit on him. When I first came to Alexandria, the bar was segregated. Interesting, yes. The Fairfax bar wasn't, but Alexandria and Arlington was segregated. The lawyer who ended up integrating the Arlington bar was Paul Sheridan. He ended up being chief judge in Arlington, but Paul and I went to Columbia together. He was a year ahead of me. He was an ex-Marine captain. I was an ex-Green Beret. And we met on the subway going up to Baker Field. He was in crew. I was a soccer player. And Paul brought a suit. There were horrible things said. I won't repeat it. The N-word was commonly used at this meeting of the Arlington bar. And we're talking about 1965. So it's my lifetime. And terrible things were said. And the African-American member was admitted. He went on to become the first African-American judge on the Court of Record, on the Circuit Court of Arlington County, Tom Monroe. In Alexandria, I tried getting two people with Bernie Cohen help me. One of whom was Otto Tucker, who was Sam Tucker's brother. Mm-hmm. Otto would do NASP work, and the bar was very clear. They had blackballed him because he did NASP work. I threatened to sue the bar. They took in two others at the time who didn't cause problems, two other African-American lawyers. And Otto never became a member of the Alexandria bar.
And I understand that you stayed away for quite some time because of the Alexandria bar's approach.
I resigned from the bar then. Many years later, an ex-partner of mine, John Grad, became president of the Alexandria bar, and he got them to drop that rule they had that any member of the executive committee could blackball people, which is how they kept African-American members out. And I did belong then for a while. I'm not big on joining things.
Well, I am a member of the Alexandria bar, but it definitely has evolved. And when I first came to this area, it was not very friendly to women either.
Yeah.
And I knew John Grad, really fine person who died way too young. But I just wanted to say that the Scholarship Fund of Alexandria has had a scholarship in his name all of these years. And I'm always proud to be able to say he was an outstanding civil rights lawyer.
Yeah. John was the founder of the Alexandria Bar Foundation when it first started. And interesting enough, he brought up women. The bar went after me. I ended up having to sue the bar. One of my, again, famous cases that went all the way to the Fourth Circuit on the right of lawyers to speak out. They went after me because I had said my client's a good guy when I was bringing a prison reform case. And I think I had 17 bar proceedings, all because of civil rights work, not from any clients back then. And I brought a federal lawsuit, won it in the Fourth Circuit, and the bar apologized to me on the front page of the Washington Post. After that, I was elected to the governing body of the Virginia State Bar for 6 years. So I would go to meetings, and the meetings were like 60 or 70 white men sitting around with ties. Some had the green pants. Only lawyers wear green pants.
Right.
plant. But 60 or 70 white guys sitting around a room, and that was mentioned. It was one African-American, Mr. Gray, who went on to become, I think, president of the ABA, a great lawyer, but from a major law firm, Lewis Powell's law firm in Richmond, but no women on it. And for 2 years, I'd make a motion to start every meeting to change the voting rules somehow so we could get integration. And I got 1 or 2 votes with me. They laughed at me. They called me names. They treated it with humor. There was some women in the room, however. The one woman attorney who was there was Liz Lacey, who was an assistant attorney general, and she was the representative of the bar at the attorney general's office. She was our counsel. And as you know, Liz went on to become an associate justice of the Supreme Court of Virginia, but she couldn't be on the governing body of the Virginia State Bar.
Yes, the state bar has come a long way as well. And I'm happy about that. In looking at your major cases and talking about all of the progress that you made, whether it's in terms of individuals being able to marry the person they choose, not being dismissed from a job because of pregnancy. And I was once, by the way, so I could be a poster person for that. Or women being admitted to the University of Virginia. There was so much progress, arguably, that your litigation and your work has resulted in. But recently, in the recent past, progress just in general, I think for many of us, has really come to a halt, especially in civil and human rights. And how does someone who has experience with the Supreme Court and arguing before the Supreme Court and looking at the current Supreme Court, how do you avoid getting discouraged?
I guess it's my age. I look at history. I consider the progress in this country a Hegelian progress. Hegel had his society advances, you take a giant step and then there's a small step backward, but you're always going forward, but there are some steps backward. And that's what we've had. So I look back to when I was a child, pre-Second World War, what it was like then in this country, what it was like for African Americans, for gays. I mean, in England, if you were a gay, it was a felony. We saw some very powerful people in terms of science who caught hell in England because they were gay. And the same thing applied here. And it changed dramatically after the Second World War and our whole treatment of African Americans, the troops coming back. And then we went through different periods. We went through the McCarthy period where things were terrible on speech, on membership things. We went through the peace demonstrations, the 1960s, the great liberalization of society. A major factor was the Supreme Court, because the Chief Justice, Earl Warren, is probably the greatest Chief Justice we ever had, and flanked by great justices, even John Harlan, who was known as the great conservative, but Black and Douglas and Brennan and Clark and the others, Potter Stewart. It was a great group of jurists who really had societal development and reasonable things on their mind. I remember as an 18-year-old joining the Army. I couldn't go to college. I had to go in the military first. I needed the money, and I certainly had a lousy high school record. We won't talk about that. But I got off a plane in Augusta, Georgia, went to a fountain to take a drink, and some guy grabbed me and said, "You can't drink at that fountain." I came from a little town, New Jersey, which was segregated, but not by law and not with labeled fountains. That was my first disciplinary procedure in the Army, because I flattened the guy's nose for telling me I couldn't drink at a fountain. But things have changed so much since then. I mean, those days, an African-American family trying to drive across Georgia, Louisiana, South Carolina, so many states, their lives are in danger. They couldn't stop and get something to eat for their children. They couldn't find a bathroom to use. There were special books of places they could stop, and most of them were not even open. I remember in '64 being in Jackson, Mississippi, and I couldn't sit down and have a meal with the woman who's now the head of the Children's Defense Fund, Marian Wright Edelman.
Yes, Marian.
We were on Farris Street. They had already just passed the Civil Rights Act in June of '64, but they weren't enforcing it yet in Mississippi, and particularly in bars, and it wasn't until later bars got into it, but particularly in restaurants. But so I look back on what life was like over those decades and years, and it has so changed to now. We're not going back to it. They're not going to now re-outlaw mixed marriages. They're not going to re-outlaw being gay. I mean, the most astounding thing I saw was the way it was accepted after the Loving case, that mixed couples could be anywhere. I see them in bars. I mean, here in Northern Virginia, we have an associate justice of the Supreme Court. He's African-American, married to a white woman, which is the thing they feared most in the South. But the ex-Secretary of Defense, Bill Cohen, he's living here in a mixed marriage, and General Powell, I don't know, Secretary Powell, whatever, Colin Powell is up here in a mixed marriage, and numerous others, and Marian Wright Edelman herself, her husband,
Yes.
Pete, who's Georgetown. And it was just widely accepted. There was such fear before that case that the Supreme Court never took one of those cases. We're surprised at the time they took Loving that they did. And the same way with gay people. It was devastating when I was a young man to admit you were gay. And early in my career, when I first started here, the person who headed the Mattachine Society here asked me to do volunteer work. So when gay people were arrested in Northern Virginia, I'd very often go down and represent them. I did it pro bono. And yet once some of these major movie actors were on TV and admitted they were gay, all of a sudden it became so much more acceptable. And so those things, we're not going back in those things. The same way with African-American treatment in society. There's no question of systemic racism in police forces. But on the other hand, we've had an African-American president. We now have an African-American vice president. We now have, we've had a chief of staff in the Army who's African-American. Those things were unthinkable when I was a young man. So we're not going back in those things. Very fundamental things have changed in our society. Some of the things our present president have done, I consider horrendous. Not because I'm liberal, just human decency would come out against it. But still don't take us anywhere near as horrendous as it was when you look at the treatment of African Americans or gays or Jews or women or so many others through the 1950s.
Well, that's a really good perspective, I think, for us to keep in mind, that we're not going backward. There may be some impediments along the way, and we certainly have a ways to go. And so while we're looking back at history and acknowledging that Loving versus Virginia and some of the other cases remain important decisions in American history, it takes on special meaning, I think, with our contemporary discussions on race and racial equity. As you say, we have come a long way, but 2020 certainly has shown us, with the twin pandemics of COVID-19 and disparities that are evident for persons of color, and with racism, that we have a long way to go. So if you're thinking, as we move forward, if you were going to continue your legal career and look for ways to litigate to achieve more progress, what would that look like? What laws would you try to change, or what laws would you encourage others to try to change?
Well, not necessarily in this order of importance, but certainly voting rights. It is horrendous the way the southern states, particularly the southern states, some of the middle northern states also, have tried to deprive African Americans and Hispanic people from having a vote. Now, we saw far worse things on the individual things. That in Mississippi, they give you a big bowl of beans. Say, guess how many beans are in a bowl if you want to vote. But that goes fundamentally to our whole process. It is somewhat impeded by the present makeup of the U.S. Supreme Court. This is far more conservative than any court in my lifetime. And I don't mean conservative on economic conservatism, which is fine, much different than I expect it to be. But conservatism on the treatment of the U.S. Constitution. Loving is a good instance. Loving is very much like Roe v. Wade. There's nothing in the U.S. Constitution that talks about marriage. There's nothing in the U.S. Constitution that talks about abortion. What the court did and recognized those, and just a few, very few other cases, Supreme Court has on occasion said that some rights are so fundamental to a democratic society that they're protected rights. They're not created and they're not written into the U.S. Constitution, but you're born with those rights as an American citizen. And in Loving, happily, they took that case and that theory and applied it to the LGBT cases. The present new justices in the Supreme Court wouldn't sign off on a Loving opinion. I don't think that Justice Thomas would sign the Loving opinion.
Wow.
He would agree that due process was violated, because how the hell do you define someone's white or black by one drop of one kind of blood or one drop of, how do you measure it? There's no fair process or procedure in those laws. But the fundamental, the equal protection argument, which is what I insisted had to be in the Supreme Court brief in Loving, there was a big dispute about that. They wouldn't recognize that. Their thing is the way the Constitution is written, that's exactly how you interpret it. And they're inconsistent. The Second Amendment shows you that. The right to bear arms, they said it's inviolable right to bear arms. So you can't bear a Stinger missile. It's a big rifle with a big bullet in it. They agreed you can't do that. And they agree you can't have 50 caliber machine guns. And AR-15 is no different. There's no sensible use for it. It's only a violence-inducing implement. So the Supreme Court is a big part of it. So the first thing I would do is go into voting rights. That it's fundamental to everything is the democratic society. Gun control, I guess you got that from what I just said a minute ago. But the lack of gun control induces violence, as the death penalty does. Put aside the other flaws they have and whether it's properly interpreted, a well-regulated militia has any meaning in the Second Amendment. But the fact is that we have a very violent society, and it's made much more so by the agreement of what we see in the federal government now. Let's rush and kill these people who are on death row. There's a president and attorney general out executing people or having their minions do it. And the same way with the proliferation of these highly deleterious arms. I would go into general speech. The whole thing that Trump has done to us, the President Trump, on the fake news, I mean, that's the huge strength of this country above the other free democratic societies, more so than England, which has criminal libel, is our free speech. Not the ability to speak as much as the ability to hear and to think and to be informed. And lastly, the Black Lives Matter movement. I say I disagree with a lot of what's in the movement, not because they're fundamentally wrong. I think they're fundamentally absolutely correct. There is systemic racism throughout many law departments throughout the United States, both sheriff's departments and city police and whatever. I think most of those officers are capable of doing their job. The real problem is the blue line. And we know this in Virginia because of the major cases where police have abused individual citizens, murdered literally. The three major ones are all white men, but the police got away with it each time. Now, recently, the last of the three cases I'm referring to is where two people in the Park Police killed a guy who was just driving away in his Jeep. And they are now being prosecuted, but it took years and years, and a congressman and a state senator, a U.S. senator. So I think that that's important. Not recognizing Black Lives Matter. Anyone half a brain has to admit Black lives, all lives should matter. And particularly Black Lives Matter because of the brutality going all the way back to days of slavery and days of, I guess, almost slavery. After Black people were freed, they were still treated like slaves. They just weren't called slaves in many parts of this country. That's something I think I would do. But that one, fortunately, there are many, many African-American lawyers now. We had virtually none in the civil rights movement who were allowed the experience to go into courts and try cases. So they were at disadvantage when you got into the constitutional field. Now, at the top, of course, there were some great legal minds. But those are the things I think I would look at now.
Okay, thank you so much. And with respect to Black Lives Matter, in looking at just demonstrating, going back to your work with the anti-war demonstrations and the civil rights movement, those demonstrations were powerful. And as you said, it really effected important change. And so do you think that there is a role in contemporary society for demonstrations in the streets for Black Lives Matter or other causes?
Yes, there'll always be that. And there'll be some violence attached to it. You can't go in the streets and demonstrate and say everybody there you've got complete control of. And the violence is almost minuscule. When you look at the number of demonstrators, the issues involved, the amount of violence we've seen in the last year is hardly tantamount to violence. I mean, no one's going to encourage throwing a burning bottle into a building off a street. But the one or two people do that, do not give credence, do not give or take credence from the movement that the people are marching down that street and expressing their views with their feet and with their signs and with their voices. And they don't take from the underlying message that there's a very deep-seated racism that's fostered throughout the United States for many, many years. We've had times with the passing of the Civil Rights Act of '64, which is still a major act, particularly in the Title VII is so commonly used now. But no one thinks twice about Title IV, which was, you can go into a restaurant and sit down, and they can't say, get out of here because of your race or your religion or your sex. So I think it's very important, demonstrations, the ability to speak out is particularly important in this area of electronic speech. That's an area I would certainly look at, the ability of people to break into others' electronic communications and then to publish things electronically, which can destroy in other people's lives. Mm-hmm. We saw cases, a group I represented, a major group, I don't get the name because individuals involved, a major civil liberties, animal rights group, had people from Anonymous go after one of their lawyers, a young woman who hadn't done anything wrong, just wrote to someone that something you wrote was libelous. You shouldn't do that again. If you do, we're going to have to take action. It was a very straightforward thing. But they went after her, they got into her emails and exposed her sex life and her private life. It was disastrous, and she'd done nothing wrong. And they were protected because they did it anonymously, but then they gave it to the big groups who do the publishing, who have the means to do that, and they're protected by federal law. It's the same law that I think should be modified, although not taken off, that the president is now trying to get put into a bill and stopping us from getting a bill out to help poor people or people being hurt by lack of employment in this virus. So you got the electric communication whole issue presents so many things to the First Amendment, to the ability to speak and protect free speech that was never contemplated by the founding fathers, that would nowhere be judged by the Constitution. There's nothing in it that deals with that sort of a thing. It's the same way the Second Amendment was never intended for the type of automatic weapons we have now.
So we can probably look forward to seeing some of those cases come before the Supreme Court in the future, I'm sure.
Absolutely.
I'm going to get to some questions that are in the chat because we've got some good questions coming in. But I just want to mention one thing about the fact that you certainly have had really high profile clients. I mean, your resume lists a long list of names that we would recognize, including Martin Luther King Jr., H. Rep. Brown, Norman Mailer, and the American Nazi Party. So what I wanted to ask you is, with balancing the rewarding work that you've done and acknowledging that you represented some clients you do not like, or you probably have taken cases that you hesitated about, perhaps, that would adversely impact your family. How did you deal with that and that kind of that balancing act and keeping your eye on the principles of free speech, for instance?
You know, I was always so busy, there wasn't time to deal with those things. That the Nazi Party erased was one of the most horrible experiences of my legal career and caused me the most pain, I think. The ACLU came to me, George Lincoln Rockwell, the head of the Nazi Party, the National Socialist White People's Party, which was centered in Arlington, Virginia, was assassinated in Arlington. And as a lieutenant commander of the Navy during war, Korean War, he was entitled to be buried in a federal cemetery. When they showed up the cemetery, they had swastikas on their arms, and the marshals wouldn't let them into a federal cemetery. And so they came to the ACLU, and the ACLU had no one. They called me up, and I said, I'm not representing a bunch of Nazis. I'm very Jewish, and my parents were Orthodox when I was born, and I'm very, very into the religion, not the day-to-day practice of it, but the heritage, the music, and the humor that I find from that religion. But, and they said to me, I put your money where your mouth is. You protect free speech. What could be more speech than this? And of course, if they can stop you from wearing a swastika, they can stop you from wearing an elephant or a donkey for one of the political parties, or a Jewish star, or a Christian cross, or so many other forms of speech to show you belong or believe in something. And we filed suit, and I got to court before Judge Orrin Lewis, who you will remember is quite a character, a federal judge here in Alexandria. Orrin, he was called. And he was told me to get my client off the stand. He'd read about it in a newspaper, and he said something about you and your friend, the Nazis. And I said, Judge Lewis, I'm here to bury Rockwell, not to praise him. I should have left Shakespeare alone, because that made the front page of the Miami Herald. And my mother's best friend came to her the next morning and said, do you have a son, Philip? And showed her the article. My mother called me, and I said, Mom, please let me explain. She says, talk to your father. My parents didn't talk to me for 2 years. It was devastating. My brothers had to step in after a couple of years and finally straighten it out. But that was hard. We were when I was a little boy in Brooklyn, people were starting to come back. My father lost a lot of his family in Germany. And people come back and telling my parents what had been happening over there. And it was just horrendous. So for me to represent a Nazi was very personal.
Yes, I'm sure very painful. We've had some questions coming up in the chat, and actually 2 individuals have asked about whether you defended students and adults during the Freedom Summer of 1964.
Yeah. I represented students in Chapel Hill who were part of the sit-ins there. It was my very first or second civil rights case. The first was a teacher case I brought in Newbern, North Carolina. But as I said before, that was the summer I was unemployed, and I was roving around shepherding and managing 200 law students throughout the Deep South. And then I ran to Bernie Cohen, got involved in the Loving case. So it was not a lot of time to do other things.
And one of the questions notes that the Washington Post noted that you had opined that perhaps the case would have been different if Richard Loving were Black and Mildred Loving were white. And And if that's the case, why do you say that?
There was a study done back in the 1950s by a man named Gunnar Myrdal on the racial relations in the United States. And actually, it's a very famous study. The Supreme Court quoted it, I think, in the Brown case. I know they quoted it in the Loving case, and it was in our briefs. And it pointed out the thing they feared most in the South was intermarriage. And the very worst part of intermarriage was a black man marrying a white woman. There were a lot of white men who went and they raped black women. They took them as concubines. From George Washington to Thomas Jefferson on down, we see a history of white planters abusing or otherwise taking advantage of African-American women. They were most afraid of that. 10 years before Loving in 1959, well, it was almost 10 years before Loving. Loving was 1967. The case of name versus name came before the Supreme Court. It was a Chinese man and a Caucasian woman out of Norfolk, Virginia. They denied review to Supreme Court. It was just such a difficult thing to face with all the things that were going on in the country then. The governor standing in doors of high schools and universities, and the University of Mississippi case, and others. They were afraid of race riots. They were afraid of a lot of violence coming up. And there was a genuine concern that taking on a mixed marriage case would feed that and be the ultimate problem. And a mixed marriage case, as I say, with a black man rather than a white man would be far more threatening to these forces of evil or whatever they were. But people with whom I disagreed, and fortunately so did the U.S. Supreme Court.
And someone else is asking if there are more recent cases in Virginia specifically that have impacted, let's see, how did he write this? Are there other more recent cases in which you've been involved that you feel may have changed laws in Virginia that affect people in their personal lives? So it's akin to the Loving situation.
Well, if it's akin to Loving or not, I mean, people's rights get violated. Most recently, several years ago, brought a case with some other lawyers, Ben DeMuro and Jonathan Mook in Alexandria. A young man had his baby taken away, and the mother of the baby just spirited the baby off to Utah, and he lost his baby forever. And we found out this was constantly being done, and Virginia had never recognized the parental rights. So we brought a suit for this young man in federal court. The federal court said, you got to go back to the state Supreme Court and send us over there. There's a special way you can do that. And we had to go argue in the state Supreme Court to establish a right for parental rights. And we established that, and it was done. We brought a malpractice case where they took a mother's medical records, and it's a baby died at Fairfax Hospital, and she choked to death, and they claimed it was, SIDS, but it was the baby just choked as they had it lying on his stomach in a soft blanket. And they used the mother's medical records, personal things of hers in the litigation. We brought suit, and that led to legislation that they can't take a woman's medical records and use them that way. And there's been a whole bunch of cases like that, none as momentous as Loving or the prison cases. Most of my practice was national, especially once I started representing the National Education Association. I did a lot of teacher rights cases in my first decade. And I represented, as I say, PETA and a number of other animal rights groups. So I went all over the country doing animal rights work, the penal reform work, not only nationally, but internationally. But in Virginia, there have been a series of cases like that brought changes in the law.
Mm-hmm. And then early on, when you were handling some of the demonstrators, and you mentioned in your oral history that you actually knew William Kunstler, and now there is, as you probably know, a 2020 movie on the Chicago 7, and my kids were watching it and looking at it as history, and I was like choked up. I mean, I was like, oh, we lived this. And for you to refer to Kunstler as Bill, I mean, all of these individuals that you knew personally, I mean, what do you think about the new light that's shining on some of those demonstrations and what happened to individuals back then who stood trial when they did their demonstrations during the 1968 Democratic Convention in Chicago?
You know, I had the privilege of helping Bill very peripherally on the Chicago 7 trial. That you needed documents from the Library of Congress. I did research on that. A young man who was part of that defense team, Mr. Ball, came here and I worked with him. And then we went to Ramsey Clark's house out in Lake Brockcroft to prepare him to testify and some things like that. I myself was involved in the DC-9 case, a bunch of priests and nuns who broke into Dow Chemical and poured blood into the files. I got a 30-day jail sentence out of that. So while Bill's for one crazy judge in Chicago, I was before a crazy judge in DC. Fortunately, 30 days were reversed 2-1, very narrowly, but I didn't have to serve it. But working with Bill, I met him on a plane going to Danville, Virginia. The second day I wasn't in civil rights, just a ransom guy. I went to a party and ended up going to Danville, Virginia. I met Bill on a plane. That next summer, I was working out of his office in New York. He and Arthur Kanoy were brilliant minds, and great human beings, and they were my mentors. So it's a privilege to do that. But the demonstrations, people speaking out, they don't change. They're more dangerous now because they're automatic weapons. You put a lot of people in the street and you get someone on a peripheral, a young teenage kid running around with an AR-15 at night as they're prosecuting someone now. And maybe he shot in self-defense and maybe he didn't, but he put himself in harm's way. And a lot of other people running around the street, and a kid that walks into a church in South Carolina with an automatic weapon like that. So demonstrating is a part of speech. It's a part of a democracy. It's a very, very strong part of democracy. And I don't know how you do without it, but given, as I say, electronic communication and the proliferation of weapons in this country, it's more dangerous.
Yes, absolutely. And I know our time is beginning to run short, but I just wanted to have you give some advice perhaps to students today or young law students today. I know in the work that I do in civil and human rights, working for a city agency, there are individuals who come all the time and they say, I'm going to law school, I'm in law school, I want to go to law school, I want to do civil and human rights, I mean, this is my passion. And I encourage them to try to volunteer or have an internship or try to do some of the work. And I know you said you were originally going to be a patent lawyer, perhaps. You had the mechanical engineering degree. I mean, obviously, your career has taken turns. And I had a dean once in college who addressed the senior class and said, make your plans, but it will be the smashing of those plans that will make your life. And that actually has come true. So what would you say to law students now who want to get into this work? Obviously, there's so much more that can be done in race relations and civil and human rights in the United States. What guidance would you give them?
Use their minds. More and more, again, electronic communications. There's so much TV, there's so much chatting on the internet and things like that, that you're inundated with it and you accept all these things and tend to believe them. So someone says, you're a liberal and those are liberal issues, or you're a conservative. Forget the labels and think for yourself. It's the most important thing you can do. And so, someone says that's a terrible liberal idea. Think, what is the idea? Look at the main issues we have in society. Are they wrong? Are they right? Abortion, I could understand. Catholic and other religious people have religious things against it. Other people think it's improper because of the embryo being a human being in their mind. Those are legitimate disagreements. But it's something to concern yourself, the woman's right to choose. Put yourself in the shoes of that woman. Maybe she's 15 years old, just got raped, and what's her life going to be like, and what is her ability to decide? Or the issue of guns. Take a realistic look. Don't think about they're taking away my 6-shooter, I'm going to defend myself. But the danger of having all those terrible guns out here. And during the Clinton administration, we put a limit on a lot of the automatic weapons. And why do you need a silencer? For crying out loud, it's only really used for criminal activity. You want to take target shooting, you can go down to a range and do that. If you're out west, you're on a ranch and there are mountain lions, they protect your sheep or something, yeah, you can have a rifle. But if you go to these individual issues, and the voting rights. I mean, how the conservative movement justifies saying to African-American people or Hispanic people, you can't vote by write-in vote. Hell, the president's been writing by write-in vote for years. So there are these issues. They're not extreme. They're postured as being extreme by the people who are opposed to them. Look at the issues. Say, is that something that being a member of a democratic society, I would want for my children? I'd want for my brother and my sister and my cousins and my parents and the people I love and the people I don't know, the strangers down the road. Use your mind. Secondly, I've had a lot of people apply to me over the years because I handled high visibility cases. I myself chose to generally avoid publicity. But a lot of people applied to me. Some very famous people worked for me and applied to me. They'd all come in and say, I'm deeply involved in civil rights. I say, well, tell me how many demonstrations, how many places you got arrested, how many, and most of them had never done anything other than say, yeah, gee, it'd be nice to do it. But when the push comes to shove and there's a demonstration to support women's rights or LGBT or whatever it's going to be in DC, they find themselves in a bar drinking with their friends, rather than marching with their feet and their voices and their whatever to express things that back a democratic society.
Good advice. And before we close, I just want to acknowledge that you say you avoided publicity, but what has always stood out to me is your humility. You have done great things, but you're humble and you're generous and giving with teaching others. And I just think that's powerful. And I'd like to close with the quote that's in Norman Mailer's book. He was a Vietnam War protester and demonstrator, and he wrote a Pulitzer Prize winning novel, The Armies of the Night, in 1968. And he described Phil Hirschkop saying he spoke quickly, clearly, with a mixture of brightness, boyishness, and driving determination. But there was implicit humor in everything he said, for it was obvious he did not believe many of the more pious sentiments he was obliged to express. What he did believe, what stood out about him, was his love of law as an intricate, deceptive, smashing, driving, tricky game somewhere between wrestling, football, and philosophy. What also stood out was his love of winning, his tenacity, his detestation of defeat. I think that is a wonderful description of you, Phil.
Thank
And
you.
I want to thank you so much for your generous gift of your time today and to wish you happy holidays. And I want to thank everyone in the audience for joining us. And I would ask you, please, to look for future programming that we will have as part of the Alexandria Community Remembrance Project. Thank you so much.
Thank you.